Hi, let's look at contracts in commerce. So, a contract is a legal binding or valid agreement between two parties. It is a legal exchange of promises and agreement or agreement between parties that the law will enforce. It can be written, this contract can be written or can be verbal, can be made orally. Okay? For example, when buying a house, a written contract would be suitable. Altogether, when buying a house, a written contract would be suitable. Now, when buying a coffee at a restaurant, oral contract would be what? Would be suitable. Are we together? Now, there are 6 elements of a valid contract. There are elements of a valid contract, and you need to know these 6 elements. Number 1, offer and acceptance. An offer, okay, is an expression of willingness to contract, okay, to agree on certain terms with the intention that as soon as it is accepted, it becomes binding. Are we together? So you offer something. If you are selling land, you give what is known as an offer, willingness to contract, to agree on certain terms, okay, with intention that as soon as it is accepted, it becomes what? Binding. Okay? Now, a contract is formed when an offer by one party is accepted by the other party. Are we together? What is an acceptance, by the way? An acceptance is a final and qualified expression, okay? Is a final and qualified expression of assent to the two terms of an offer, okay? Unqualified, of an offer. It must be communicated, okay? It must be communicated. Now, after acceptance, now signing of a contract. Signing a contract is a one-way party, okay? Is a one-way you show, or someone show, or a party show his or her assent. Are we together? Okay? In order for a contract to be formed, the parties must reach mutual assent, meaning meeting of the minds. You agree, okay? You agree, you are all satisfied. Oh, yes. Now, you assent the contract, or you sign. All right? So this means that one party makes an offer for a bargain and another accepts. Are we together? Good. We are still looking at the first element of a valid contract, which is what? Which is an offer and acceptance. The person making an offer is known as an offerer, and the person receiving the offer is known as the offeree. Okay? An offer can be made to an individual or a group of people or the entire world. Are we together? That is about offer and acceptance. The second element of a valid contract is consideration. Consideration, it is a price paid for the promise of the other party. The price paid for the promise of the other party is what is known as the consideration. Now, the price must be something of value, although it should not be money only, okay? Something of what is something of value. It may be some rights, interests, or benefits going to one party, detriment, loss or responsibility given. suffered or undertaken by the what? Suffered or undertaken by the other party. As long as consideration exists, the court will not question its adequacy, provided that it is of some value. For example, the promise to pay a goat in return for a lease or rent of a house would be a good consideration. Okay? It must not be illegal or impossible to perform. Are we together? That is consideration. Number 3, intention to create legal relations. The third element of a contract states that a contract does not exist simply because there is an agreement between two parties. The parties to the agreement must intend to enter into legally binding agreement. Okay? Remember, we are on intention to create legal relations. The agreement must show that the parties had the intention of entering into a legal binding agreement. Okay? Into a legal binding agreement. This will rarely be stated explicitly or clearly, but we will usually be able to be ascertained from the circumstances in which the agreement was made. For example, inviting a friend for lunch every day is not usually intended to create legally binding relations. However, you may have agreed with your friend that he or she makes a contribution of, let's say, 150 every month towards lunch. Here, the law is more likely to recognize that a binding contract was entered into. Are we together? Very good. Very good. Now, let us look at the fourth element of a contract, which is legal capacity. Legal capacity, this is the legal ability to enter into a contract. The legal ability to enter into a contract. You should know that not all people are completely free to enter into a valid contract. The following have no legal capacity to enter into a valid contract: people with mental impairment. So you can't be saying, I bought this farm from that gentleman. If someone is mentally ill or impaired, you cannot enter into a legal contract or legal binding valid contract. That contract will be considered null and void, because the person is not mentally stable. Another set of people who have no legal capacity to enter into a contract are minors, children. Tungo, sign here, do this, do that. No, you just lose your case, or you lose your land, or you lose your car. Minors are not legally, do not have the legal capacity. Okay? Bankruptcy. Okay? The bankruptcy here, this is usually when the business is not making profit, or a business where the business collapse. Okay? You cannot enter into an agreement. Prisoners, they have no legal capacity, etc. Are we together? Number 5. The fifth element of a contract is certainty or consent. certainty or what? Consent. You know, entering into a contract must involve the elements of free will and the proper understanding of what each of the parties is doing. Okay? Don't just sign anyhow contracts like our forefathers. We are signing the Lochner Treaty, those treaties they used to sign, especially in the Balose with the whites. Okay? The consent of each of the parties to the contract must be genuine. Okay? It must be clear as to what it must state. Okay? As to what the parties have agreed upon. It must be very clear. All the essential terms to be settled between the parties must be settled. The ultimate consequences of establishing that no proper consent was given to enter the contract are matters dealt with when considering remedies for breach of what? Breach of contract. Another important point that you should know is that proper consent may be affected by 1. Mistake. 2. False statement. 3. Duress. And number 4, undue influence. Undue what? Influence. Okay? The sixth and last last element of a contract is legality of the agreement or contract. A contract is void if it is based on an illegal purpose or contrary to the public policy. Where a contract is illegal, this affects its enforceability. Okay? Contracts that are illegal by statutes will be regulated as to enforceability by the statute. Thus, the statute will need to be read and interpreted. Certain types of contracts are illegal because they are contrary to the public good. For example, a contract to kill someone, contracts that are sexually immoral, contracts intend to promote corruption in public office public office, defraud the revenue, etc. Are we together? Now, let me explain something here on the first element, which is the three parties of the contract. You should have an offerer, a person who is offering who is giving an offer, and the offeree, the person receiving the offer, and there has to be a witness when signing the contract. Okay? Now, we're going to use examination questions to answer. We're going to work will be examination questions. Remember, we've looked at the contracts. We've looked at contracts. That a contract is just a legal binding or valid agreement between two parties. Okay? Or it's just an exchange of promises or agreements. It can be written or verbal. Okay? Now you can't be saying, like, you want to buy land, you say, tinamverana. No, that will be that's illegal. Okay? You can only do that when buying sweets, when buying chickens. Okay? But in one or my shops, that's when you can do that contract. Okay? But when buying a house, you're supposed to have a written contract. All right, so I hope you've enjoyed. Thank you so much. Let's meet in the next lesson.